Good morning. Happy Monday. Some people take the position that if someone is your adversary in a particular context, that you need to, I don't know, wage total war against them. I don't take that particular position. I like to make sure that any statements I make, any conclusions of law that I draw, are based in reality. And reality is different sometimes than what you read in the statutes. There's, some things are illegal, but they're not enforced. I mean, you could find these rules, these laws on books in several places, like, sodomy laws or, no shopping on Sunday laws, things like that, where they haven't been taken off the rule books, but they're not enforced. And there is a very low probability they would ever be enforced. And one of the things that people seem to want is for Chillie to be charged with perjury for signing his various complaints under penalty of perjury. Now, one person in my comment section suggested that Massachusetts perjury law might apply, and I don't think so for several reasons. Number one, for the Massachusetts perjury law to apply, the perjurious statement, the signature under penalty of perjury, would have to be done on a complaint that was filed in Massachusetts court. Chillie's complaint against Kate specifically, and Josh, even his Ironton complaint, which would be a completely different state that Massachusetts would have nothing to do with. So why are you talking about it, John? Anyway, his complaints were filed in federal court, and so federal jurisdiction would apply, which means that you'd be looking at 18 USC whatever for perjury. So Massachusetts law would not apply. Massachusetts perjury laws would not apply. Now, let's just assume, arguendo, that he actually was filing a complaint in Massachusetts state court. Well, he's not required to sign his complaint under penalty of perjury. And Massachusetts perjury laws require that the perjury laws apply to instances where someone is required to sign under penalty of perjury. A pro per signing a complaint in Massachusetts just means that they've signed the complaint. If you're an attorney and you've signed the complaint, it means a few other things, at least my understanding of Massachusetts Rule 11 as I'm not licensed to practice in Massachusetts, but my understanding of their Rule of Civil Procedure 11 is that only attorneys are signing under, on information and belief. To the best of their knowledge, information, belief, something is true. Non-attorneys aren't signing under that. They're just signing it. So it wouldn't apply. In addition, looking up Massachusetts case law, I could not find a single case in Massachusetts where someone was charged with, let alone convicted of perjury for signing a complaint in Massachusetts court under penalty of perjury. I mean, it doesn't exist. So now why did Chillie sign under penalty of perjury? Well, again, he signed in federal court. But in Massachusetts, you're not required to sign under penalty of perjury. If he, for whatever reason, he was required to sign it under penalty of perjury, and he signed it under penalty of perjury, then a prosecutor would have to show that he willfully and intentionally made a false statement. Now, generally speaking, when you're signing a complaint, you're signing it saying, on information and belief. To the best of my knowledge and understanding at this point, I believe this to be true, is really what you're signing under. And maybe it's something that you think you'd be able to have evidence later that is going to substantiate your claims. A lot of times people write in on their complaint, on information and belief X, their factual statements, the ones that they know are like, on this date X, And then on the things they don't know, it's on information and belief. Why, right? And then in California, we have verified pleadings, verified complaints, which you don't have to do, but you can do. It changes the way that the response has to come. You can't just do a general denial. You have to do a specific denial if it's a verified complaint, yada, yada. But the verified complaints, generally, the verification page generally reads, I so-and-so am the plaintiff, and I assert the above allegations and believe them to be true, except for those which are based on information and belief. And those I believe to be true, are true. And those on information and belief I believe to be true, etc. So, but the whole point of a lawsuit, you expect discovery to come. You expect that process to happen. And so it would be weird for a court to say, well, wait a minute, you have to know all of this stuff ahead of time on a complaint before you file the complaint. But then what's the process of discovery for? Why would we even do that if you have to know everything ahead of time? So it doesn't work. And then he did file under the federal rules of civil procedure. He did not have to sign those under penalty of perjury. I don't think that's fatal to his complaint. I don't think anybody cares. It is a thing that he did that he didn't have to do. But the Federal Rule of Civil Procedure 11 is a little bit different than Massachusetts Rule of Civil Procedure 11. Anybody who signs, be it the attorney or the pro se litigant, when they sign, they're saying to the best of their knowledge, to the best of their understanding, to the best of their belief, these things are true. And I believe I have factual. You're also saying that I believe for all the facts, I have evidence to support it. Or after discovery, I'm going to have evidence to support it. By the time this whole thing is resolved, I believe I'm going to have evidence to support it. Now, you might say that he's still committing perjury, and that's fine. But again, I didn't find anybody who has been charged with, let alone convicted of perjury for a statement that they made in their complaint that was not factual. I've seen attorneys get sanctioned over it, but that's not perjury. That's a sanction because, the attorneys are held to a bit of a higher standard. And if the attorney is aware of a non-factual statement being made, then that attorney might get sanctioned. But not perjury. So if you're holding your heart, your hope out for Chillie getting charged with perjury, that's not a statistical possibility, let alone a probability. The odds of that happening, I mean, there is some odds of it happening. I mean, anything is possible, but that possibility is going to be so slim, it's going to be negligible. I don't understand why anybody would even believe that a charge is going to come from that. It's not going to happen. It's not going to happen. I mean, it's just not going to happen. So, keep your copium, copium, whatever it is. I'm not really familiar with the memes as I should be, I guess. Is it hopium or copium? I think in this case, it'd probably be hopium because they don't need to cope. Chillie's huffing copium, but I think most of the commenters who are hoping that Chillie gets charged with perjury are snorting hopium, not copium. Anyway, so thank you for watching. Another thing that people have been asking me about is whether or not Chillie can sit for the bar, and they want me to do a long, exhaustive review of what you need to do to be able to sit for the bar in California. And you need to graduate from law school, or you need to be apprenticed to a licensed practicing attorney for, I think it's 3 years. And the hours that you have to accumulate, the attorney has to be reporting on that. They have to set up the arrangement with the state bar, and they have to report the hours that you spend working as an apprentice in their law firm during this process. It's scrutinized by the California State Bar. So Chillie is at a bare minimum, at least 3 years out. And I believe he would also have to have a degree, in order to get into law school. He'd have to have a bachelor's degree of some sort. And most likely, I think to apprentice, he's going to have a bachelor's of some sort. I might have to look that up. But again, worrying about Chillie taking the bar, again, is something that is so low on the list of possibilities that it's not really worth time and effort for me to go in and research exactly what would have to happen for him to challenge the bar. It's not happening. He's not going to do it. He wouldn't, even if they let him sit for the test, there is still the multi-state professional responsibility, MPRE, multi-state professional responsibility exam that he would have to sit for and pass in addition to the California State Bar exam. And he would then have to pass a background check. And the background check is going to be a problem for him because they, like courts, they can find all of these things where he took pretrial deferment. They can find all these cases in Oregon and Alaska, and he has so many hurdles to jump, and he would have to answer for all the times where he may or may not have been practicing law without a license. He would have to answer for that. And if the Ohio Supreme Court does anything to sanction him, he's done. California will recognize what Ohio did. The California State Bar will recognize what the Ohio Supreme Court did in sanctioning him. So if that happens, I mean, he's super done. But it's, again, this is like this isn't a thing, guys. Like, this isn't a thing. It's not going to happen. Chillie has a better chance of getting a judgment against Kate and enforcing it than he does sitting for the California State Bar. Sitting for it. Not even like becoming an attorney, just sitting for it. He has a better chance. He's not going to pass the test if he sits for it because he doesn't know a damn thing about law. He's not going to pass the MPRE because he doesn't know a damn thing about ethics. And he's not going to pass the background check. So, like, literally, even if they let him sit for the bar, he still has essentially a 0% chance of passing and becoming an attorney. So it's not a thing. He's not going to get charged with perjury. He's not going to become a California attorney. Not. He's just not. So don't waste valuable time thinking about it. It's not going to happen. Thanks for watching. Have a great day.